My name is Gregg Ivers. I'm a professor of government in the School of Public Affairs at American University in Washington, D.C., and welcome to the fourth chapter in my ongoing series, Hidden Civil Rights History in the Washington, D.C. area. I'm on the campus of the Howard Law School, which is located in upper northwest Washington, just off Connecticut Avenue on Van Ness Street. It's about 4 or 5 miles west of the main campus of Howard University, which is, of course, one of the nation's oldest and most famous historically black colleges and universities. So perhaps the first and most obvious question is this: what am I doing on the campus of the Howard Law School on a quiet Sunday afternoon, thank you COVID, when I'm not a law professor and certainly not a law student? The LSAT made that decision for me a really long time ago. The answer is this: no other law school in the country has been more responsible for destroying the legal architecture of white supremacy in the United States than Howard. And that, as we'll see, is a tradition that continues to this day. Howard University was chartered as a private, non-sectarian institution by an act of Congress in 1867. Although Howard historically has been open to all persons without regard to race, color, or gender, it was established primarily to serve the needs of black Americans who had been denied a meaningful path to higher education, whether as a consequence of enslavement or, in the case of free black men and women, the discriminatory admissions policies of American colleges and universities nationwide. Howard was also unique among black colleges and universities in that it offered graduate and professional training beyond the undergraduate degree. A law program to train black attorneys to serve the needs of the black community was part of that vision. In January 1869, Howard admitted the first students to its law school, which was headed by John Mercer Langston. Langston had graduated from Oberlin College in 1849 and the Oberlin Theological Seminary in 1852. After completing his degrees, Langston decided he wanted to study the law, but his applications to law schools in New York and Chicago were rejected on account of his race. He was able, however, to read for the law under the supervision of abolitionist attorneys in Elyria, Ohio, a small town about 10 miles northeast of Oberlin, and in 1854 he became the first black lawyer admitted to the Ohio bar. For almost the next 20 years, the Howard Law School did not have a building of its own in which to hold classes. Students either met their professors in their private homes or in local office buildings, but that minor inconvenience did not prevent the law school from leaving its first historical imprint on American legal education and practice. In 1872, Charlotte Ray graduated from the Howard Law School and was admitted to the D.C. bar that same year, making her the first black female attorney in the country and the first woman admitted to practice law in Washington, D.C. In 1883, Mary Ann Shadd, who had been active in abolitionist causes prior to the Civil War and had earned a national reputation as a publisher and social activist, graduated from the law school, making her the second black female lawyer in the United States. In 1887, the university purchased this row house at 425th Street Northwest, giving the law school its first permanent home. It would remain there until 1936, when the law school moved to the main Howard campus. In 1974, Howard relocated the law school to its current address in upper northwest Washington when it purchased the Dunbarton College of the Holy Cross, which, from 1935 to 1973, had been an undergraduate Catholic college for women. In 1929, Howard University President Mordecai Johnson decided to transform the law school from a part-time evening program with no full-time instructors into a national institution that would attract and provide black law students with a first-class legal education. Johnson had been receptive to the criticism of several of his well-placed friends in Washington, including Supreme Court Justice Louis Brandeis, that the law school needed a reboot from top to bottom so that black lawyers could receive better training. But one of the law school's part-time instructors, himself a rising young lawyer in Washington, had already been on Johnson's case to turn Howard into a full-time accredited day program and had been working his own contacts throughout D.C. to support a revamping of the law school. That instructor had studied the problems facing black legal education and presented Johnson and the Howard trustees with some stark and troubling facts. In 1928, there were 160,000 white lawyers in the United States. In contrast, there were around 1,000 black lawyers nationwide and less than 100 licensed to practice in the former Confederate states. In Alabama, Mississippi, Louisiana, and Florida, for example, there were 4, 6, 8, and 10 black lawyers admitted to practice in those states. The reason was obvious. There were no black law schools for students in those states or anywhere else in the Jim Crow South. This made it even more imperative to make Howard a destination for black law students. That same instructor also happened to be the person chosen to take on this challenge. As dean, he would shake the Howard Law School to the rafters, turning it into a boot camp for the first generation of black lawyers who soon became an elite strike force against the legal pillars of Jim Crow for decades to come. And just who was that instructor making all this ruckus? None other than the great and incomparable Charles Hamilton Houston. Charles Houston was born on September 3, 1895 in Washington, D.C. He grew up in the house that you see here, located at 1444 Swan Street Northwest, right in the heart of a neighborhood known as the U Street Corridor. At one point, Houston lived about half a mile from Duke Ellington, who grew up in two separate homes on the 1800 block of 13th Street Northwest between the years 1910 and 1917. Whether Houston and Ellington knew each other in their youth or ever crossed paths is something I would love to be able to tell you, but I can't. In 1924, Houston's parents bought this home at 1744 S Street Northwest, about half a mile from the Swan Street residence. Charles would move into this home in 1943 with his second wife, Henrietta Williams, and their 3-year-old son, Charles Hamilton Houston Jr. The S Street home is now part of the D.C. African American Heritage Trail, and you can see this sign as you walk on by. At a time when most black students in Jim Crow states were funneled into industrial training schools modeled on the Booker T. Washington approach to black education, Houston attended M Street High School, D.C.'s sole black high school offering a college preparatory education. He graduated in 1911. That fall, Houston entered Amherst College, where he was the only black student in his class. He graduated in 1915 as class valedictorian. After returning to D.C., Houston taught English for 2 years at Howard before enlisting in the Army. He arrived in France in October 1918, just about a month before the war ended. Houston remained there until February 1919 when he returned to the United States. In April 1919, Houston left the Army at the rank of lieutenant colonel. Houston's treatment in the Army, whether at segregated training camps at home or under the supervision of white American officers in France, stiffened his resolve to attack racial segregation and discrimination after returning to civilian life. Of the discrimination and humiliation he experienced and witnessed during his time in the Army, Houston later wrote, "The hate and scorn showered on us Negro officers by our fellow Americans convinced me that there was no sense in my dying for a world ruled by them. I made up my mind that if I got through this, I would study law and use my time fighting for men who could not strike back. My battleground was in America, not France, and I am damn glad I did not lose my life fighting for this country." Houston enrolled at the Harvard Law School in 1919, where he quickly became a top student. He counted future Supreme Court Justice Felix Frankfurter and the law school's dean, Roscoe Pound, among his early mentors. And Houston became the first black student elected to edit the Harvard Law Review. But that academic success did not make the social isolation he experienced at Harvard any easier than his time at Amherst. Houston was not invited to join any pre-professional or social clubs at Harvard, which, like Amherst, tolerated black students as long as they stayed in their place. He graduated in 1922 with honors, then spent an additional year at Harvard, earning an advanced degree in the juridical sciences. In fall 1923, having been recommended by Frankfurter, Houston took a prestigious fellowship to study law at the University of Madrid. In 1924, Houston returned to D.C. to join his father William's law firm. It was then that he began teaching part-time at the Howard Law School. As dean, Houston wasted no time in reshaping the law school to meet his exacting standards. He eliminated the night program, improved the library's holdings, and raised admissions requirements. By 1931, Howard was accredited by the American Bar Association and admitted to membership in the Association of American Law Schools. Houston was strict and tough as nails, and not just as dean. He still taught and made clear to his students that he expected them not only to excel, but to go out in the world and make a difference. Although Houston was well schooled in legal jurisprudence and theory, he also understood better than many others the difference between the way that law was taught from the books and how it was practiced on the ground. He instilled the belief in his students that law and litigation were dynamic instruments that could be used to change the legal landscape for Black Americans. And it's no stretch to say that Charles Hamilton Houston and the first wave of students under his supervision at the Howard Law School pioneered the practice of 20th century public interest law. As he later wrote, a lawyer is either a social engineer or a parasite on society. A social engineer is a highly skilled, perceptive, sensitive lawyer who understands the Constitution of the United States and knows how to explore its uses in the solving of problems of local communities and in bettering conditions of the underprivileged citizens. Among the first students to arrive at Howard after Houston had taken charge was Thurgood Marshall, a Baltimore native and recent graduate of Lincoln University. Marshall had wanted to attend law school at the University of Maryland, but didn't even bother to apply because of its whites-only admissions policy. But if Marshall went to Howard expecting to coast, based on its previous reputation, he and other members of Howard's first full-time day program were in for a shock. They soon discovered that the new dean, who also taught their constitutional law class, had no patience for mediocrity. Marshall graduated in 1933 at the top of his class. More importantly, Houston had seen enough in his star student to make him his protege, a choice that would have historic consequences. Their relationship soon shifted from teacher-student to partners as they geared up for the legal assault on racial segregation. That summer, Houston, who had been working part-time with the NAACP, invited Marshall to join him on the first of several fact-finding trips throughout the Deep South to document the horrid conditions of public schools for black children there. Funded by a small grant from the NAACP, Houston and Marshall traveled by car throughout the region, talking with teachers, administrators, parents, and children about their experience, supplementing their interviews with data on the vast inequalities in facilities, expenditures, and curriculum. Houston wrote regular articles for the NAACP's magazine, The Crisis, and published a regular column called Along the Highway, which ran in black newspapers around the country. They also used an 8mm camera to record the conditions of black schools, lest anyone believe that they were making any of this up. But there was still the not-so-small problem of Plessy versus Ferguson, the 1896 decision that codified racial segregation under the 14th Amendment, based on the legal fiction that racially segregated facilities did not offend the principle of equal protection as long as they were equal. And just for the record, the phrase separate but equal never appears in the Plessy opinion. In 1931, the NAACP's first staff attorney, Nathan Margold, published a report recommending that it attack segregation in the courts by focusing on the disparities between white and black schools rather than attack segregation as a constitutional principle. At that time, the latter approach was too risky, and a negative precedent would cripple any future effort to overturn Plessy. By 1935, Houston had left Howard for New York to work as the NAACP's chief legal counsel. And part of Houston's agreement with the NAACP was that the Howard Law School operate as a research and development arm of the NAACP's legal program. This close relationship between the Howard Law School and the NAACP continues to this day. After a couple of false starts, Houston and Marshall won their first victory in Murray v. Pearson, a 1936 decision in which the Maryland Court of Appeals, the state's highest court, ruled that the University of Maryland must admit Donald Murray to its law school because it had no law school for black students. Houston also secured important victories for the NAACP, equalizing teacher salaries in Maryland and Virginia, and many of those cases were argued by Howard law graduates. After the Murray decision, Marshall closed down his Baltimore law practice and joined Houston in New York as his second-in-command. 2 years later, Houston would return to D.C. and join his father's firm, where he remained until his death in 1950. But he continued to oversee and guide the NAACP's campaign in the courts. In 1938, Houston argued the NAACP's first successful public education case in the United States Supreme Court, Gaines v. Canada. The justices ruled that the University of Missouri must admit Lloyd Gaines because it had no equal facility for black students. Houston ultimately argued 8 cases before the Supreme Court, and not just cases involving public education. He won 7 of them. For his lifetime of work, as an advocate, as a strategist, as an educator, and as a litigator, Charles Hamilton Houston would earn the nickname, the man who killed Jim Crow. Marshall, of course, would soon become the face of the NAACP's litigation campaign. He argued 32 cases before the Supreme Court and won 29 of them, including Briggs v. Elliott, perhaps the toughest of the 5 cases decided together as Brown v. Board of Education in 1954. Marshall left the NAACP in 1961. Later that year, he accepted President John F. Kennedy's nomination to serve on the Second Circuit Court of Appeals, and in 1967, nominated by President Lyndon Johnson, Marshall became the first black justice and only Howard Law graduate appointed to the Supreme Court, serving until 1991. Until his death in 1993, Marshall credited Charles Hamilton Houston with setting him, and so many others, on a path that changed America. But Marshall was not the only Howard Law graduate to contribute to the quiet revolution that the NAACP was leading in the courts. Richmond native Oliver Hill, who graduated with Marshall in 1933, became a prominent civil rights lawyer and was part of the team that argued Davis versus the Prince Edward County School Board out of Farmville, Virginia, another one of the Brown cases. His long-term law partner and co-counsel in the Davis case was Spotswood Robinson, who graduated from Howard in 1939. Robinson later became the first African-American judge to serve on the United States District Court for the District of Columbia. Robert Carter, a 1940 law school graduate, worked under Marshall for years at the NAACP and was the attorney of record in the actual Brown versus Board of Education case. Carter won 21 of the 22 cases he argued before the Supreme Court and later became a federal judge. George Hayes, a 1918 Howard Law graduate, was lead counsel in Bowling versus Sharp, which came out of D.C. Had Charles Houston been alive at the time the Brown litigation went to the Supreme Court, he more likely than not would have argued that case. Houston had spent years suing the D.C. School Board over the condition of black schools. So added up, 4 of the 5 cases decided as Brown versus Board of Education were argued by Howard-trained lawyers, and the 5th, Gephardt versus Belton, was argued by Lewis Redding, Delaware's first black lawyer who counted Charles Hamilton Houston as one of his mentors. Howard's outsized impact on legal education and American society, though, extends far beyond this historic period in the development of modern civil rights law. Pauli Murray, who graduated at the top of her class in 1944, wrote a paper for her then professor, Spotswood Robinson, arguing that racial segregation violated the Constitution because it demeaned blacks as people and citizens, a position that the NAACP legal team would later embrace as it got closer to Brown. Murray later became the first woman to be ordained as an Episcopal priest. Dovey Johnson Roundtree, class of 1950, secured a landmark victory before the Interstate Commerce Commission in 1955, outlawing segregation on interstate bus travel as one of the first achievements of her distinguished career. Vernon Jordan, class of 1960, who went to work for the legendary Atlanta-based civil rights attorney Donald Hollowell after graduation. Jordan later served as executive director of the National Urban League and the United Negro College Fund. Doug Wilder, class of 1969, who became the first elected African-American governor in the United States when he won Virginia in 1992. Walter Washington, class of 1948, who became the first elected mayor of Washington, D.C. in 1974. Sharon Pratt, class of 1968, became the first woman elected as mayor of Washington, D.C. in 1990. Adrian Fenty, class of 1996, continued that tradition by winning a term as D.C. mayor in 2006. Loretta Copeland Biggs, class of 1979, became the first black woman appointed to a federal court in North Carolina. And Letitia James, class of 1988, is the current Attorney General of New York, the first African American and first woman to serve in that position. Let me put this another way. If the Howard University Law School was a basketball team, none of the incoming players would have numbers on their jerseys because they'd all be retired and hanging from the rafters. But if you get there on bobblehead night, perhaps you can get one of these instead. I hope you've enjoyed the 4th chapter of my ongoing series on hidden civil rights history in the Washington, D.C. area, and I hope you've learned something as well.